Well, this is John McConnin, and today I'm talking about the 4 liability traps caused by the realtor forms and the process. Basically, the 4 traps an attorney should help their clients avoid, and consequently themselves if you're making the referral. 4 traps you can avoid that I talk about in my listing attorney and coaching program. And the reason I'm going to try to make this fast, so we cover it in more detail and other things, but this is all intermixed. It's all meshed, and I want to just cover it quickly and then go to the actual forms where I think we can make a difference, something I haven't discussed yet today. So first of all, because buyer agent commissions were switched from the listing agent's money that they pre-negotiated to a third-party contract between buyer and buyer's agent, and then the buyer then checks a third-party beneficiary clause in the contract, the liability for offering buyer agent compensation has effectively been switched from realtors to the sellers. And one of the major liabilities, it's still there, that's obvious, would be compromising the fiduciary duty of the buyer's agent. And another one would be steering. And a third one that wasn't really part of the class action suits, but was liability that realtors and others said would be incurred by sellers, is offering inconsistent levels of buyer agent compensation to protected groups. And finally, and it might seem like a stretch at first, but it'd be overpricing the home and having participating in a scheme that kept commissions really high. And that's still there in spades, and it could be easily mitigated. So that's how we got to 4. Now, I'm not going to go over the whys of all this, but in the first spot, I'd go to start every form with 0. You want to document it in writing. Realtors will tell you, hey, we can't offer buyer agent compensation. We can't even put it on the MLS. That's true. But every listing agent is going to be talking to their sellers about the costs and commissions. And they are, unless they're going to dummy up and appear stupid. And that's what realtors never want to do. They always want to seem like the authority on sell a home so they get the listing. They're going to talk about it. And that speech will be a problem for both the seller, the listing agent, the brokerage, the whole thing. Any talk, later when the class action attorneys or even disgruntled buyers or any buyer who wants to sue based on the liability created by this process, that's like an easy one. So you were talking about commissions, and I think the easiest way to eliminate that problem is to make sure it's put in writing. Now, this is also then a great time to explain all this to your clients, and then they're going to know you're going to need to introduce your client to a realtor who understands the whole process, so a good realtor, and you're going to have to do the work, so you should be getting paid. So, I've created this whole process that allows you to get paid $10,000, and there's also a way to get 50 or 60% of the commissions, and you do not have to become a broker to do it. You just have to follow the right format. If you're going, well, we'll talk about all of it and other things, but that's the intro. Now, so first of all, it's start at 0. That's one way. Second of all, it's counsel the seller. The third way would be to mitigate the risks. I've talked about all this in other videos, but now I want to get a little specific. So I'm going to try to bring in a new scene here. I hope this comes in, and it does not. That's me. I did set it up properly this time. Okay, so that's a seller. This would be, I would use this form. It could be a forms-driven process. So I make a form like this or this if you specifically want this one available. And then I explain all the risks here to the seller. So this is how you would counsel. It's forms-driven. This would then introduce the idea that you'll still be working. You can help them, and you'd introduce it to a realtor. So it's a very logical process when an attorney would be talking to someone in their practice who needs to sell a home, whether a divorce, trust and estates, probate, just because you know a lot of people that are selling homes and you counsel them. I mean, you want to start with that 0 form. That's available at listingattorney.com/form for free. I'll send it to you. And I'll also give you links to all these videos and at least the video explanation of the program. But now I want to get to this. This is a counter offer. This is a massive risk that I see for attorneys. You're being expected to sell, to help your seller or refer them to an agent. And this is what a counter offer looks like. This is the blank lines right in here that an attorney, that a realtor, well, it really can only be an attorney. That's my point. All of this is boilerplate. It's useful, but it's boilerplate. But now this is where a realtor is expected to write in terms, and they're legally could write because it's a fact. Box A3 is changed from 1.9 million to 2 million, because those are facts. The seller's telling them the price, they're countering. In the Sipper case, People v. Sipper, notice I said People v. Sipper, stated that realtors, if they're only acting as scriveners or writing in facts, they're not practicing law without a license. But when they start writing in words that affect have legal impact on third parties, then they're practicing law without a license. And I'd like to point out specifically, if they're selecting the form, and in this case, they're selecting a blank form when they really should have two forms. One form, like this one, to deal with the price and terms of the home, which realtors can do because they're only changing facts and dates and things that a seller could tell them. Or when they're dealing with a third-party beneficiary clause and a third-party beneficiary contract, they should be selecting that, and they should also be including risk mitigation on that form. So yeah, we're amenable to 3% buyer agent compensation, but if we're paying 3% buyer compensation, you need to waive your rights to lawsuits. You need to acknowledge that the source of the funds could be said to be coming from the buyer. So you're paying your agent. We're doing it as a courtesy. We're instructing escrow to do it, but the money's really coming from you to pay your agent. And therefore, just so you know, the price of the home wasn't inflated. You could ask us to reduce the price of the home by that amount. It really is your convenience. There's lots of other ways to mitigate. There's better ways than that to mitigate, but that's some of the things your sellers could do. And that's some of the things an attorney has to do to mitigate a client's risk. I see those as the risk, but you should note that this process can also, and in all probabilities would, like in real estate, in one contract at a time, it's hard to say that if you follow this bifurcation process, you will sell your home for more. But I will guarantee you, in my experience, in my bones, I know that when you're countering, if you break this out into two forms, seller is amenable to buyer agent compensation, but please do request that on this other form. By the way, we're countering here, and we can conduct the negotiations here. You're going to get the buyer and the seller coming together on the terms on this agreement while you're still keeping that other one in play. And because you're keeping that other one in play, that agent's going to realize they better get this thing done and keep the sellers happy, or they're likely to see their commissions get reduced dramatically in that final round. Because after a buyer and seller lock in, a realtor really doesn't have an ethical leg to stand on to say, I'm blowing up your deal. You're going to have to still pay me 3%. Because most likely the buyer's already told them and checked the box, says we can't pay you out of our own pocket, because if we could, we'd be getting a better house, or we'd be, we're using all our money we can to buy a down payment now and get qualified to get this house. They're not going to have extra 30 grand, 3% to pay their agent very often. And so, if you set this up right, you're going to sell for a higher price. If you set this up right, if you're not happy with the price, you're going to reduce the buyer agent commissions lower. So in all probability, an attorney's going to help their clients sell a home for a lot higher net. So you've got the liability introduced when a realtor's writing this, and you're allowing them, they're practicing law without a license. If they don't discuss the risks and your client's not aware of the mitigation of the risk and given a choice on how to mitigate them, that would be practicing law without a license by that realtor. So that liability, you've referred them. Like if you gave 3 referrals, fine. But if you're referring to your agent, I see that as liability. I'm sure you understand what I'm saying. But finally, let me go back. If I can go back to the final point here, let's go back to this product roadmap. Because you've done all this work, I don't think your seller has to pay you $10,000 more per file. I'm telling you, for me, I've sold 200 homes. California Association of Realtors has had me train realtors on multiple offer situations. If you're using our process, especially this part where you're attempting to develop multiple offers also, but you're properly responding, you're properly counseling, you're helping them with disclosures. If an attorney's involved in doing all that, they've earned at least half the real estate commissions. But I know lawyers are allowed to sell homes, but they're not supposed to be doing it for a percentage base. So I'm going to tell you, I have that firm belief that if you're doing these things to help your clients sell for more, help them sell for a higher net and mitigate the risks, to me, that's at least $10,000 on the file of legal work. So if you're doing that work and the myriad other things, the counseling, the disclosures, the reviewing the contract, that's easy. So out of my share, I would make sure you guys got paid $10,000. So if I'm in San Diego and we're working for 2.5 or 3% on the listing side, having you do the work, easy. Now, if you're already have realtors, you like to work in other areas, you're outside of Southern California, you could have a listing broker, an attorney broker like me, be the co-broker. Then you could have that person. So you're talking to the seller. The seller signs the agreement with the listing attorney / broker, and then they can bring in local brokers and local realtors. And there's still 2.5%, 3%. There's still plenty of time for you to get paid for the work you're doing. You could have an attorney broker who will still be there to actually, like, who's going to counter and get on the phone and talk about a third-party contract? Let me just say, the listing agent is not authorized in writing to do it. They're not authorized to draft the language. They're essentially not authorized to do any negotiating. So, if you're referring to a realtor, but there's no attorney in there who's actually going to do the negotiating or could do the negotiating, I mean, it's possible it's all done on forms sometimes. But in the end, when they're close, but you don't want to cancel and blow up the deal, but you'd like to get a little more, that's where an attorney who's got language saying you're authorized to discuss this third-party beneficiary clause with the third party and discuss their contract terms and see if there's some room over there so that they can still get the deal done, and you can help them do that because you're an attorney in case they're aware of their limitations. I mean, that's also invaluable. So you put an attorney on your team, you're good, you get to do the work. You can be coached into helping your client if you're new to this. All of that's available. But my point is that working with realtors and their forms introduces significant liability. And really, luckily, you're an attorney, so you can mitigate it. You can actually eliminate your liability and mitigate most of the risks your seller incurs when working with realtors. So my name is John McConnin. Find out more at listingattorney.com. Thank you.